and that there will be a Q&A towards the end of the webinar. And of course, first and foremost, we are very excited about your questions and comments that you may have now or going forward. And we kindly ask you to post any questions you may have in the course of the webinar in the chat. And when it's time for the Q&A, I will call on your questions. And we also encourage you to engage with this webinar and the broader conversation around intersectional approaches to international criminal law and justice on social media by using the hashtag #IntersectionICL or tweet @IntersectionICL. And to open this webinar series, which means a lot to me and all the people who have worked on this for quite a while, thank you so very much for joining us today. I'm thrilled it is finally happening. It has been a long time in the making. Hence, I'm also a little nervous, but mainly excited for what is to come in the next 19 minutes. Very briefly, my name's Alagendra Lily-Cather. I use she, they pronouns. I'm the co-organizer of this webinar series together with Anna Martin, and I'm also the co-founder of the Emergent Justice Collective. Before we kick off, I'd like to express my gratitude to the Transitional Justice Institute for their support in hosting the event, in particular Sadie McGee and her team, to the Unit of Global Justice at Goldsmiths University, London, in particular Kirsten Campbell for her mentorship and support throughout. And to this extent, the team behind the webinar series stands in solidarity with colleagues at Goldsmiths who are currently on strike against 52 redundancies, which in part would lead to the eradication of entire departments. And to support those striking and learn more about the reasons behind it, follow or look up #GoldStrike on Twitter. I'd also like to thank my colleagues at the Emergent Justice Collective, Ashley Jordana, who's here today, Valentina Atsarova, Lisa Marie Hudi, Amanda Garimani, as well as Kate Wignes-Varan. And thank you also to Suchen Tsang and Ledin Kainkonen for their organizational support over the last weeks, and to Gabi De Luca for creating the really beautiful visual identity for the webinar series. And before you and I will hear from our truly stellar discussants, I'll offer some reflections, among others, on the origin and concept of intersectionality, which will be followed by opening remarks. After the input of each of the discussants, there will be a time for question and answer as already announced. And again, thank you so much for joining us this evening or afternoon. So diving right into the subject matters, the concept of intersectionality was coined in 1989 by Kimberly Crenshaw. And in particular, in her essay entitled Demarginalizing the Intersection of Race and Sex, a Black feminist critique of anti-discrimination doctrine, feminist theory, and anti-racist policy. And with coining this concept, she really provided us with a multi-axis framework to understand and account for the discrimination experiences of Black women in the United States at the time on the basis of race, sex, and class. She did not only provide a multi-axis framework to better and more holistically understand discrimination experience, but to also visualize the systems that exist in truly upholding and systemically contributing to ongoing inequity. She puts forward in summary that intersectionality is a lens through which you can see where the power comes from, where it's hoarded, but also where it collides and where it interlocks and intersects. And turning to the discussion today with respect to international criminal law and practice, an intersectional approach to designing really any kind of justice processes and responses would first and foremost essentially require the centering of lived and contextual experiences at truly all stages and all forms of international criminal justice work. By diving into such reflections and meditations around intersectionality and ICL, I'd like to underline the importance and the acknowledgement that concepts such as intersectionality, for example, and particularly those that emanate from rather specific contexts cannot and should not be transposed or applied without reservations everywhere and without questions being asked. So in particular, for example, in post-colonial context or context of ongoing colonization, a single axis lens did never constitute an established or predominant approach nor reality. And what we are looking for in the discussion today and the discussions we will have in the months to come are not really definites, but visionary, future-oriented responses or even questions that are adaptive in nature that can move with us as we move along, finding the answers to them. And these questions or responses, they may respond to a certain discontent in the field of international criminal law with both the cooperation and work practices that are often reluctant to actually acknowledge and work with existing power hierarchies and privileges. So in addressing these structural impediments in the way of international criminal justice work and the way it's being carried out, the trick is really whether we can provide also affirmative suggestions, what could work in the future and how this can be implemented. And in this, I'm asking us all to be open for such responses, to be inspired and guided by, first and foremost, by lived experiences, as well as disciplines other than law. I'm thinking in particular of psychology, health, history, post-colonial studies, critical race theory, queer theory, but also more practical outputs of academic disciplines of practice, such as design thinking. And as such, these solutions need and will be interdisciplinary, if not multidisciplinary in nature. I now give the floor to our first person providing opening remarks, which is Siobhan Wills. And she's currently the director of the Transitional Justice Institute at Ulster University. So thank you so much, Siobhan, for you and your colleagues at the Institute to offering a space to hold these discussions. Prior to her current position, she was the course director of the LLMs at Human Rights and Transitional Justice and Gender, Conflict and Human Rights. And from 2014 to 2018, she was a member of the International Law Association Committee on the Use of Force. And accordingly, her research interests are the protection of civilians, peacekeeping, and the use of force. Siobhan, the floor is yours.
Thank you. Thank you. It's wonderful to have you all here. I find it very excited. I'm delighted to welcome all of you on the web to this webinar, the first in a series of 4 on intersectionality and international criminal justice, which has been organized in part by Anna Martin, a PhD student at the TJI, and Alagendra Lilikaha, who has just spoken to you. And the series is funded in part by a small grant from the TJI. So it's really exciting that this is happening. And my role is to introduce the discussants. We have 5 discussants on today's panel. And I'm going to apologize that I probably will mispronounce some names because they're unfamiliar to me. So I'm really sorry for any offense. So the first person that I'm going to introduce is Professor Patricia Viseur, who is an international criminal lawyer and a visiting fellow of Kellogg College at the University of Oxford. She's also a practicing professor at LSE and a senior research fellow at the Human Rights Center of the University of California, Berkeley. In 2021, she was appointed as the Special Advisor for Slavery Crimes to the Office of the Prosecutor of the International Criminal Court. She was previously a Special Advisor on Gender to the ICC, and prior to that, she was the Legal Advisor for Gender at the ICTY from 1994 to 2007, and at the ICTR from 1995 to 1999. Professor Sellers has developed legal strategies that led to landmark decisions regarding sexual violence as a war crime, crimes against humanity, genocide, torture, and enslavement under international criminal law. So it's wonderful to have you here. Our second speaker is Dato Shyamala Alagendra Khan, who is a Malaysian lawyer. She is the Gender and Child's Rights Advisor to the Independent Investigative Mechanism for Myanmar, and she was the Assistant Director of Public Prosecutions of Fiji and has served as a prosecution trial lawyer and counsel before several international and hybrid courts. So it's wonderful to have you here. Dr. Yassin Brunger is a lecturer in human rights law and a fellow of the Senator George Mitchell Institute for Global Peace, Security and Justice, just down the road, sort of, at Queen's University, Belfast. She's founder and co-director of the Queen's Gender Network, a coordinator for the Interest Group on Feminism and International Law of the European Society of International Law, and an expert member of the AHRC-funded UN Gender Network and the AHRC Working Group on a Feminist Approach to Peace. She has received national recognition for her contribution to the first Black History Month campaign in Northern Ireland and currently serves as co-chair of iRise, the university's BAME and International Staff Network. Our next speaker, it's great to see you, Yassin. I know Yassin, so it's great to see her here. The fourth person on our panel is Adejoké Babington-Ashaye, an international law expert with over 19 years of experience in international criminal law and investigations, human rights law, and the international settlement of disputes. She has worked with the World Bank, the International Court of Justice, and the International Criminal Court. She's contributed to the UN Office on Drugs and Crime training modules on counterterrorism in the international law context and on gender dimensions of criminal justice responses to terrorism. And our fifth speaker is Anna Martin, a doctoral researcher here at the TJI, who has been investigating the applicability and benefits of intersectionality in international criminal law for crimes of sexual and gender-based violence. She's also an international lawyer, and she's worked in transitional justice issues in Spain for Amnesty International and against child exploitation for ECPAT International. It's wonderful to have you here, and I'm going to hand the panel back to the Alexandra Lily Kappa. Thank you.
Thank you so much, Siobhan, for the kind introduction. I'm now going to introduce our two persons that will provide the opening remarks, which are Lorraine Smith-Van Lin and Ashley Jordana. So Lorraine Smith-Van Lin, she, her, is an international human rights lawyer and a truly dedicated advocate for the rights of victims and women. And she currently works as an independent international human rights consultant, and she is the founder of the Talawa Justice for Women, a newly founded nonprofit organization dedicated to connecting and equipping women leaders of survivor and grassroots organizations from the Global South. And some of her previous roles include the prosecutor and parish court judge in Jamaica, the director of the International Bar Association's The Hague office, and the legal advisor at Redress. And Lorraine has, among others, authored numerous reports and academic articles at the ICC, including on victims' participation and reparations. And in 2019, she was also profiled by Atlas, so was Shyamala, Adejoké, and Patricia, which is an influential global network of over 8,000 women lawyers for a contribution to international law. And last, but definitely not least, is Ashley Jordana. She also uses she, her pronouns. She's a Canadian barrister practicing in international justice. She's presently an advisor to the United Nations Office of Drugs and Crime and a co-founder of the Emergent Justice Collective. And between 2016 and 2021, Ashley was the senior legal advisor at Global Rights Compliance, where she led the investigations and strategic litigation portfolio, working with several accountability actors, including the ICC, and the UN mechanisms across many conflicts. She also in 2016 joined the Stanislav Defense team at the United Nations mechanism for the international tribunals, and she's a rostered expert with Justice Rapid Response, particularly when it comes to crimes against children. And her dedicated commitment is to build an international constituency to ensure that international investigations and accountability efforts effectively address violations and crimes committed against children. And now, finally, I'm going to hand over the floor to Lorraine for the opening remarks. Thank you so much.
Thank you, Lily, and thank you to all those who organized this amazing event. I just want to thank you, first of all, for having me make in a few minutes, just a few opening remarks about this really interesting theme of intersectionality, and to do it in the company of such amazing experts on this issue. As Lily said, part of my work and my background has been working with victims of crime either in Jamaica when I was a prosecutor, or and now I work with a number of women in Uganda and in Kenya mainly. And when I sat and thought about how to open such an important discussion, the first thing that came to mind is, how do we as practitioners, as advocates, as activists in international criminal justice reflect in our daily practice, in our work, the lived experiences of these victims? Are we capturing in the charges that are put forward in the courts exactly what they are experiencing? Are we really reflecting it in the sentences that are handed down, in the decisions of the judges? Is it really reflected when we develop and implement reparations? And using intersectionality as the framework or the lens for thinking about some of those considerations, I realized that at the very core, to me, intersectionality is about addressing and making clear the nuances in terms of the not just lived experiences, but identities of experiences, social, cultural, economic, political identities and structures. How do we unpack that in the context of international criminal law and international criminal justice? And the other question I asked myself was, what does it really mean when we say international criminal law or international criminal justice? Are we here limiting ourselves to intersectionality in the context of formal justice mechanisms? Because I then began to open my mind to broader understandings of justice. So for example, I thought of transitional justice processes and you know, traditional justice processes. And I asked myself, given, and in particular, looking at the International Criminal Court and how the International Criminal Court, with the principle of complementarity, has a much broader reach and influence and hopefully impact on national prosecutions of international crime and national understandings and permutations of how certain international violations are interpreted in national courts. I thought that it was really important for us to have this discussion because of the potential knock-on effect in national proceedings. And so my very brief remarks will be centered on two specific issues, which I call my A's. And I deliberately use A because we are beginning, although the discussion I started as Lily said with Kimberly Crenshaw, Black feminists, we are to some extent still at the very beginning, I would almost say. We're still at the cusp of this in ICL. And so I start with the first A, which is acknowledgement. I think it's an acknowledgement. We firstly need to acknowledge that it is not enough to have a unisectional approach to harm. It is not enough to look at victims as this homogeneous group of persons that experience harm in one way or experience harm, you know, in a single dimension. It is important to look at the compounded effects of harm. And this is something that I have seen personally. I recall being in Uganda during a victims network meeting and hearing victims talk about, and survivors talk about their experience of being abducted in the insurgency in northern Uganda, and speaking about the particular experience that they faced as women who had suffered sexual violence, but women who had children arising out of that sexual violence. So the women were actually almost experiencing the trauma through their children and the children through their mothers. But then some of them had been injured. So they were also in a category of being disabled. And then thinking through how reparations or other programs addressed only one part of their experience, but not experiencing and not discussing this in you know, looking at the multidimensional aspect of this. I would say that we've seen at the ICC in particular, we have seen some experience of, you know, I would say very positive movement in embracing intersectionality as a concept, where, you know, we moved from, for example, the Lubanga case, where there were very narrow charges which excluded the lived experience of girl soldiers. And we moved to the Ntaganda case, for example. And I deliberately mention that because I'm particularly taken with the approach that the trial chamber in the reparations decision in the Ntaganda case has taken. And I find it very, very useful because for our discussion here in terms of looking at the way forward. And for example, the trial chamber was very clear in noting that it was very important to take an intersectional approach to reparations and how reparations are designed and the persons that are to be considered as part of reparations. In fact, the chamber noted that due consideration should be given to the existence of previous gender disparities and power imbalances, as well as the differentiated effect of harm based on the victim's gender expression. In the words of the chamber, a gender inclusive and sensitive perspective should integrate intersectionality as a core component. And we are seeing very, very good progress in this area. We are seeing, for example, this is intersectionality as a language included in the Office of the Prosecutor's policy papers on gender and on children. And this is the kind of progress that we want to see at the ICC. We're seeing also in some of the more recent cases, Al Hassan, Yekatom, and Ngasona and Said cases, right? We're also seeing where the more nuanced legal qualification by the prosecutor of discriminatory violence targeting and affecting protected and vulnerable groups will present the judges with a new opportunity to make a substantial jurisprudential contribution to the law of core crimes that implicate intersectionality. But I don't have time to go in it, there are experts here. I think it is so important that this does not stop within the walls of the ICC. What for me is particularly important is that this discussion, and when we're thinking about moving forward, that this discussion goes beyond how we interpret formal justice, how we look at ICL, and begin to see the kind of knock-on effect, as I said in the beginning, on national processes, because this is where we're expecting to have greater resonance. And we're seeing a little bit of some rays of hope in that regard. I want to just leave you with one. The AU Transitional Justice Policy, for example, doesn't use the word intersectionality, but it does provide that transitional justice measures should address not only the actual violations against women and girls, but also the structural basis involving patterns of gender bias, discrimination, and inequality in the social and public spheres. We've seen also General Recommendation 28 of the CEDAW Committee. It outlines that states parties must legally recognize and prohibit intersecting forms of discrimination and their compounded negative impact on the woman concerned. So I think this beginning with this discussion in ICL is wonderful. And we need, the ICC is the right place to start in the sense of making sure that when we get it right at the ICC, and in this context, it will move beyond the ICC into other frames. But I also want to say that it is absolutely critical as practitioners, as academics, that we ensure that when we are thinking about it, it is not what we say from here, but it is also ensuring that those who we serve, the communities, the victims, that they also have an opportunity to indicate what their understanding of intersectionality is, because it's a fluid discussion. It also involves them. It also it changes. And this is what I myself am learning as I interact with these women. The last thing I will say is this. When we talk about ICL, it is not just about prosecution and formal justice processes. It is also about messaging. And so I want to drop something in here. It also has to do with public information and outreach. The public and information and outreach arms of the court, how are they ensuring that the message goes forth? How are they ensuring that intersectionality is part of their messaging, both in terms of how they deal with affected communities and how they carry forward the work of the court and what the court actually does? And so I'll just leave these thoughts as a starting point for what I think will definitely be a much longer discussion, and say thank you again for the opportunity.
Thank you so much.
Thank
Lorraine.
you. Thank you.
I might hop in now then. Thank you so much, Lorraine, and thank you to Lily. Your words are sort of this really humble reminder to me that the conversation that we're having today and the conversation that we're going to have in the next few months are really built on ideas from women who have created before us. And so I wanted to thank you for that reminder. As Siobhan introduced, my name is Ashley Jordana, and I am one of the co-founders of the Emergent Justice Collective. I think when introducing a new organization, there's sort of this temptation to try to impress your audience with the technical work that the organization does. But what I actually want to mention about the collective, perhaps it's because it's what I value most of it, is that this is a feminist-led coalition of lawyers and advocates who are not only committed to applying an intersectional approach to investigating and challenging global injustices, but it's a group of individuals who are really committed to doing the personal work as well. And by that, I mean by continuously examining our positionality, our privilege, and our use of power. And that for me has really been the heartbeat of the collective. And that said, we will pop some information down into the chat box so that you can follow along the technical developments of the organization. I wanted to begin these opening remarks with just a reiteration of the words on our invitation, and that is that this is really a space for exchange and learning. We know that there have been some traces in what we call an intersectional approach in ICL, but there's by no means a formal methodology. And I think all of us may have a different understanding of what it actually means, and that's okay. So I want to reiterate that this is the place to have that conversation and to exchange learning on those topics. So considering that, and considering that many of these notions are sort of undefined for many of us, I thought that with the few minutes that I have, I would share my own personal understanding of intersectionality in ICL using a really simple approach. I was thinking about Lubanga, and I thought, well, I'll use the details of Lubanga because I think most of us are probably quite familiar with the details of the case. Now, in Lubanga, while it wasn't specifically charged, we heard testimony of sexual violence crimes being committed against young girls who likely suffered that abuse because of their gender and their age. Now, there's no analysis taken because they weren't charged, but failing to do an analysis of their gender and the intersection of their age really prevented us from understanding that these young females experienced a very unique type of violation because of the intersection of their gender and their age. So it was our task to acknowledge that. And in addition, because I believe that it is the systems of oppression that form the backdrop of criminal conduct and therefore individual criminal responsibility, I believe it was also our task to understand the relationship between those grounds of discrimination that I mentioned and the various systems of oppression that existed at the time. So in Lubanga, one might have, for example, inquired about the historical, exploitive, sexual, and economic relations and imperial servility that existed within that analysis. I think actually Lily sums it up quite nicely when she says that the trick is to hold an accused responsible in their individuality, but as actors within multiple intersecting systems of oppression that influence their criminal conduct. So in other words, that ICL shouldn't be the surface accountability that doesn't dive into the deeper systems of oppression that exist. And so for me, bringing this all together, I'm really looking forward to exploring if there is a methodology in ICL practice that can unmask that interaction between those systems of oppression while uncovering the root causes of discrimination and also capturing the full experience of harm that's been caused. So I'm really looking forward to discussing this. Can we develop the tools, the methods, the theories to really capture and respond to the various lived experiences in atrocity crimes in a way that doesn't appropriate or supplant the concept from its roots? So I think I'm going to cut it short there. But I'm going to pass it over Lily now to start the discussion. So thank you all for being here and really looking forward to it.
Thank you so much, Ashley. And before I give over to your first speaker, I would just like to sincerely apologize on behalf of the organizing team. The event has been trolled by very racist and harmful, violent remarks. We do apologize, and please know that myself and the team will track the chat and attendee list to prevent any of these attacks further. Our first speaker is, I don't even know how to summarize it, but for many of us, a trailblazing visionary for feminist international lawyers, and I'm sure very much beyond that. Her work has meant incredible amounts to myself and other peers. Thank you so much, Patricia, for your pioneering work, everything you've done, and I'm very much looking forward to hearing your remarks on this topic, particularly if you think of intersectional approaches in international criminal law and practice in the past, present, and future. What are some of the things you'd like to share with us today in the context of the discussion?
Thank you very much, Lily, and the other organizers. I guess I do have to reflect to say that we were just trolled because it remains dangerous for women to have the nerve to talk about law, and it remains dangerous for women of color to have the nerve to talk about international criminal law. Well, we are here. That's what I want to say. In terms of intersectionality, I realize that I'm the first speaker in the beginning of what will be a very long and rich conversation. So I just want to set forth some initial ideas. I hope we can circle back to them, but I hope they become some of the threads that we'll pick up in this multi-series webinar. Intersectionality is primarily an analysis that concerns vulnerabilities of survivors and victims, but vulnerabilities that manifest as identities. And we should remember that these identities could be temporary, or they could be permanent identities of these survivors or victims. Vulnerabilities really are a way of saying what is the structural underlying of the crime of the society. And it is this structural underlying that actually the vulnerability is prompted by. By that, I mean that what drives atrocity crimes in particular is the vulnerabilities of the victims as initiated by the perpetrators. It's almost a tripartite. When one has a vulnerable survivor or victim, one has an aware perpetrator. But let me give some examples as I go along. When I say identities, the identities could be age, and we know age is mutable, that could change. Gender can be non-binary. Race, just until now, is non-mutable. But we have to remember that race really doesn't exist. The race at times is in the eye of the perpetrator. Abilities and disabilities, they can be mutable, they can change. Religion also can change, as can one's ethnic orientation, such as whether you were bicultural, and you might adhere more to the Iranian side of your family one day or to the Puerto Rican side of your family the other day. So when I look at vulnerable identities manifesting themselves, I really do mean they could be temporary or permanent, and it does depend upon the view of who is looking at it and how the person might be self-identifying. Also, I'd like to say that vulnerable identities can be overlapping, compounding. For an example, let's look at Guatemalan children who are Ixil Mayan, who were transferred to other groups, and specifically the army families that were massacring their parents. Well, what does this mean? This means that when we understand the Guatemalan genocide, and we only focus on the intersectionality of men who were killed, who were Mayan, because they were accused of collaborating with guerrilla groups that were non-Mayan, that were basically urban, but we don't turn and look at the children who were not killed, who were not necessarily sexually enslaved, but who were transferred to the families of the Guatemalan army. What we are seeing is an intersectional approach of vulnerability to a group that in essence was submitted to an act of genocide. The intersectionality of the genocide is refracted and reflected in those Mayan Ixil children. Now, one could say, and often we have, concentrated on killings, or we concentrate on the sexual violence that occurred to their mothers and sisters. But we have to continue that our analysis takes us to where the crimes occurred. And we understand that the transfer of children was because they were children, because they were Mayan children at this time period, to families of the very perpetrators. However, it should be stressed that international criminal law, from a very large or panoramic point of view, understands vulnerabilities and identities that are captured in vulnerabilities very well. One could understand that the Geneva Conventions, in and of themselves, protect vulnerable populations, those who are shipwrecked, those who are wounded, those who are prisoners of war, or civilians under certain circumstances, and particularly detained civilians. The Geneva Conventions go even further to talk about you cannot have adverse discrimination against a person in these vulnerable groups based upon sex or health or age. So it's not as if vulnerabilities has not already been identified, and it's not part of what I go back to, the core of why we have certain international crimes. The same could be said for what looks like a very broad category, the civilian population. Well, the reason we have crimes against humanity is we understand that the civilian population in and of itself can be vulnerable at times, can be vulnerable to widespread or systematic attack. And within that vulnerability, we can specifically go to acts of persecution, where we go down to the subgroups of the civilian population, being even more vulnerable during a time period of widespread and systematic acts. We certainly know that the different genocide groups are basically a detailing of vulnerable groups. And so this notion of intersectionality and the compounding of vulnerabilities, it sits somewhere in international criminal law, but it hasn't been surfaced, contemplated, conceptualized, acted upon, implemented in terms of charging strategies, whereas some of our speakers have already said when looking at reparations. Each of these vulnerable identities in and of themselves lead to other intersectional identities. For example, when you look at Yazidi women, think about the elderly Yazidi women who were part of the mass killings immediately with the military-aged men. So military-aged men as a subgroup of the Yazidi, elderly women as a subgroup of the Yazidi, two intersecting vulnerable populations. That intersectional analysis allows us to understand that from the perpetrator's point of view, those were useless women. Those were women who could not serve them in terms of enslaved women. They were women who would not go to war for Daesh. The elderly women, when we look at it from that intersectional analysis, really explains to us the operations, the policies, and as a matter of fact, the objects and aims of the perpetrator. We see that in the perpetrator's own understanding of their conduct, intersectionality. We see that they understand the vulnerabilities of the populations that they have attacked. And as a matter of fact, this is how they carry out the genocide. This is how they carry out the crimes against humanity. Their operations try to enforce vulnerabilities of these identities. So intersectionality is completely swimming around the mind of the perpetrator. It is embodied within the laws itself. And we know that within all of our populations, we have intersecting compounded vulnerabilities and identities. Thus, take the Khmer Rouge experience. The Khmer Rouge reconfigured the pre-war or pre-genocide human being who was a male intellectual, who was a city dweller, and transformed those vulnerabilities, those very temporal vulnerabilities, because being an intellectual in Cambodia was not per se a vulnerability prior to the Cambodian genocide. Being a city dweller was not necessarily a vulnerability prior to the genocide, nor was being a male. But when the Khmer Rouge came, that very person becomes the enslaved laborer in the Cambodian countryside who is castigated because they are an intellectual. However, I do want to underscore that intersectionality as an analysis is weakened when we only look at persons as being neutral or even neutral in time. There are positive parts of identities that always exist, as there might be negative parts as perceived by society. But I'm trying to underscore that there are mutable vulnerabilities, depending on time, depending on the situation, depending on the lens of the perpetrator. Another thing that I think intersectionality has to take into account at its very root, and I hope this becomes part of our discussion, is that intersectionality cannot be ahistorical or devoid of the experience of the legal genesis of a crime. Now, Ashley has already spoken about how we have to look at, for example, discrimination prior to the occurrence of, let's say, sexual violence at war. But I would say that we have to acknowledge the historical roots of crimes to understand how intersectionality even prompted the prohibitions. And let me just give one or two examples. In the Holocaust in Germany, it was very necessary to understand that it occurred against not only a Jewish population, but a mixed race population, against a disabled population, against adults and against children, against persons who were assumed to be homosexual or to be social deviants. We have to look at that as an intersecting of vulnerabilities as the aim of various stages of the Holocaust. And this has informed the Genocide Convention. So when we look today and we see, for example, as I mentioned, the Guatemalan children who've been transferred, or we could look at the stolen generation of Australia, or we could look at the indigenous children who've been placed in schools within the United States and Canada. We shouldn't be mystified and say, well, how does that fit into genocide if we understood that during the Holocaust, that there were children who were presumed to look like Aryans, who might have been Jewish or might have been Polish, who were transferred to Norway to be raised as good Nazis. If we understand the intersectionality of that very comportment or conduct that is infused in the understanding of the Genocide Convention, it helps us to unpack, I think, intersectionalities today. So therefore, let's not be ahistorical. When we look at enforced disappearances, let's not deny, let's not deracinate the legal and factual origins that come from Latin America. These overlapping vulnerabilities in Latin America, imprisoned political females and males who were also at times married or the female pregnant, they disappeared. That might help us look and understand the disappeared in the Syrian context today, or the Yazidis who've disappeared today. When the slave trade or slavery are denied or deracinated from their legal and factual basis of the East African trade, the West African trade, and everything that entailed both slave trading and slavery, if that is denied, we will never understand what the migrants are going through in Libya today, male and female, being continuously traded, sexually abused, and traded. If we just reduce that to something that's weak and ahistorical, or want to easily call it trafficking, we will lose the intersectionality of a historical approach. So therefore, let me just reiterate that Kimberly Crenshaw, when she examined these overlapping intersectional identities, she made them alive because they came from a historical basis that was continuing. It wasn't just the fact that it was women or just Black women, it was Black women workers in a racist employment situation where they could not be advanced. And it was understanding both the historical root, the present intersectional, structural disabilities imposed upon these vulnerable identities that gives us the very basis of intersectionality. I'm hoping as we look at international criminal law, we do not completely think we're inventing something new, but we do understand that we are on a new journey in terms of intersectionality. Thank you very much.
Thank you so much, Patricia, for incredibly gracefully and eloquently, as always, setting the scene for the conversations to come. Next up is Shyamala. And from our conversations and preparations for this discussion, she has told me about her truly incredible work as the Assistant Director of Public Prosecutions of Fiji, where she played a leading role and really changing role in the prosecution of child rape cases. And that included securing the first life sentence ever to be imposed for child rape. And of course, beyond this, she has worked as a prosecution trial lawyer, as well as has acted as a defense counsel before the ICC and other international courts and tribunals. And against this backdrop, I would really like to ask you, for the purpose of this discussion, whether you can give us your thoughts on intersectionality, really based on your experience prosecuting international cases so far. And also perhaps going into your ideas and visions around where we can do better, and your suggestions around how we can ensure an intersectional lens is truly and effectively applied in such cases. Shyamala, the floor is yours, and thank you so much for being with us today.
Thank you so much, Lily. I'm really pleased to have this opportunity to say a few words and to share my thoughts on the subject. So thank you very much again for having me here. Let me just begin by acknowledging that much has been written about intersectionality from the feminist perspective and from the vantage point of the law, civil rights, history, and sociology. But if you boil it down to its essential essence, intersectionality, to my mind, simply provides a framework that challenges us and indeed requires us to recognize that systems of oppression frequently interweave to the disadvantage of a particular group or individual. People are often simultaneously disadvantaged by a convergence of oppression by dint of their age, gender, class, color, religion, even geographical location, or other perceived identity markers. To ensure we don't prioritize one dominant, or shall I say one perceived dominant identity marker, and push other aspects of an individual's identity to the background, intersectionality to me is then a framework that is resourced by the lived experiences of victims and survivors. I intend to use my few minutes to focus on intersectionality and how it can be a tool that will help us do better by children. The discussions around intersectionality and the value it has to enhancing accountability and justice has almost entirely been around adults. Although the ICC's child policy expressly states that investigation methodologies should include an intersectional analysis to understand significance, age, and birth, and the degree to which they may give rise to multiple forms of discrimination and social inequalities, either alone or as they intersect with other factors like race, ability or disability, religion or belief, ethnic or social origin, gender, sex, sexual orientation, or other status or identity. Despite this, in the ICC child's policy, children are largely absent from this rich discourse on the relevance and importance of applying an intersectional approach in international criminal accountability processes. I think we all agree that children are inherently intersectional beings. Children are more vulnerable to human rights violations because they are disadvantaged or targeted not only on the basis of their age, but because their age intersects with other grounds, their ethnic origin, their gender, or their religion. Crimes against and that affect children, especially in the context of the work we do, is often a consequence of disadvantage, discrimination, and persecution against the community to which the child's parents belong. This has to be noted. At the same time, it is essential that that factor does not then diminish the other identifying markers, which increases the vulnerability of particular groups of children. In order to fully address violations against children, investigations and prosecutions must consider the lived experiences of children and how their personal identities or characteristics intersect to make them targets of certain types of crimes, as well as the impact those crimes have on them and the community to which they belong. The ICC's prosecutor's policy on children specifically recognizes that acts targeting children on the basis of age or birth may be charged as persecution on other grounds, and recognizes that children may also be persecuted on intersecting grounds such as ethnicity, religion, and gender. I'd like to add for a moment here that under the Rome Statute, persecution as a crime against humanity occurs in connection with any of the crimes listed in Article 7, or in relation to any other crime under the jurisdiction of the court, which would then also include persecution committed in connection with war crimes. Despite this recognition, and leaving aside counts related to child soldiers as war crimes, as far as I'm aware, so far no international court has prosecuted age-based persecution, even where it was clear that children were the main intended targets of some of the crimes. I will use the Yekatom case. I was in fact going to talk about Lubanga, but I will use the Yekatom case for the sake of provoking discussion. The prosecution in that case charged the recruitment and use of children under 15 in hostilities. It appears that criminality was not viewed through an intersectional lens. If it had been, perhaps consideration may have been given to charging persecution against the children that were forcibly recruited by the anti-Balaka group. We need to ask, why were the children targeted? It appears they were targeted not only because they were children, but because they were Christian. And the perpetrators viewed that Christian children would support them as anti-Balaka, and therefore were suitable for attacking the Muslim population. The Taganda case law provides that these children would have been protected persons under IHL at the time they were forcibly recruited, at the time they were subjected to rapes and sexual slavery by the anti-Balaka that recruited them. By only focusing on the persecution of the Muslim civilian population in that case, there is a danger that the Christian children were rendered largely invisible, save for being used as child soldiers. The point I'm making is this: child group identities in atrocity crimes are not only defined in terms of age. Children are frequently persecuted or otherwise targeted because of their age, but also because of additional intersecting characteristics that children share with the social group that they're a part of. An intersectional approach allows us to stand in the shoes of the child, whilst also looking at crimes through the mind, understanding, and motivation of perpetrators. This 360-degree review of why crimes take place and why particular individuals and collectives are targeted compels us to then zoom in on them and to understand all the identifiers that are unique to that child or those individuals and groups in that particular situation. International crimes are complex. They are difficult to prove. They are resource intensive. Judges and effective prosecutors, naturally, we wish to have expeditious trials. For my part, I don't insist that intersectionality leads in every case to multiple charges in relation to the same conduct. But I do think intersectionality is essential to understand the context in which we work, and it will guide us to look at what we may otherwise miss. It disciplines us to adapt our processes and inquiries to the realities of victims and the situations we are working in, so that we are not applying a model of accountability that was in fact designed for some other group or someone else in mind. To bring intersectionality alive requires not only a theoretical understanding of the concept, but to me it is a call to action that requires diversity in teams investigating and prosecuting these crimes, and diversity in our sources of understanding and information. When I first became familiar with the concept of intersectionality, I considered my own experiences, and I realized that in the most effective teams that I was a part of, we implemented an intersectional approach, even though we did not know or use that label or that concept. This to me demonstrates the solidity of the concept It's not academic. It has real world advantages. I felt we used this kind of a framework when we were situated in situation countries for considerable periods of time. We used it when we had a fair representation of lawyers, investigators, witness support staff, analysts of all genders from the situation country, as well as from the concerned ethnic communities within that country. It was when we interacted directly with victims and survivors from a wide geographical base, and when we sought out women and also children as part of our work. It also was possible when investigators were simply interested and curious enough to want to understand the social and cultural context of the cases we were bringing and how these social and cultural realities contributed to the commission of crimes. Instructing cultural experts at an early stage of investigations was also an extremely important aspect of the work we did, and it helped us understand the complexities and nuances of particular cultures and groups. Insiders or perpetrator witnesses, I think, are an excellent source of evidence to understand how and why individuals and groups are targeted in the ways that they were, and to understand the intended impact of the crimes on the victims as well as on the targeted groups. Having experienced female interviewers or prosecutors interviewing this category of witness was essential in my view. At the Special Court for Sierra Leone, I interviewed as well as led the testimonies of critical male and female insider witnesses in the trials that I worked on. This really capped my understanding of the context of the cases I prosecuted there, and it gave me that 360 view on how the pre-existing vulnerabilities of especially women and children informed and actually fed the discriminatory policies and criminal conduct of perpetrators. This link was not lost on the judges, who I believe grasped it during the testimonies, and this was also reflected in the final judgments, especially the RUF judgments. I've also found that engaging directly with women leaders from ethnic communities is so essential. Engaging with Rohingya women leaders and representatives at the outset of our work at the Myanmar mechanism has meant that our investigation strategies and policies have been guided by their voices and their choices. And this is the same with all the women and women's groups that we have interacted with from all the other ethnic groups. Speaking to them and learning about the structures and the strictures that affect their lives directly from them has been indispensable in our intersectional inquiry. Bespoke investigative strategies must be adopted in different situations. This is precisely the utility of an intersectional approach, which is the antithesis of a unidimensional one, which tends to exclude, to omit, and to distort. I will end by saying this, that when an intersectional lens is applied at every stage of the process, we are more likely than not to put forward an accurate and inclusive narrative in the cases we build. It will ensure that our work is imbued with the voices and lived experiences of victims and survivors, instead of drowning them out or replacing them with our assumptions and frequently our distorted view of what we think happened and what we think the impact of those crimes were on the affected victims and communities. If we get this right, we will allow victims to really be the authors of their own stories, instead of us molding their histories on the image of a justice system, which in fact pushed them into the shadows and marginalized them all over again. I'm really looking forward to learning through this series on how I can do my work better and applying this approach effectively. Thank you so much.
Wow, thank you so much, Shyamala, for these powerful, really, truly calls for action for all of us that are so very informed by the practical realities of what it means to do this work, and also your concrete ideas of how intersectional approaches can be infused on the practical level. So thank you so very much. Our next speaker is Yassin, and you are a long-term scholar and activist, and thank you so much for being with us today. And could you share with us how intersectional approaches or intersectionality more broadly comes up in your work?
Thank you so much, Lily, and the organizers for this invitation for what is a really, really important discussion. I think I want to pull us out of the mechanics and operations of international criminal law for a second and start with a conversation about how we understand intersectionality. Now, there may be people in the webinar who are more familiar with it, who have more advanced knowledge, or maybe completely new to the concept. And I think that's something that is important for us to perhaps locate ourselves in. As mentioned earlier, we pay homage and recognize the work of Black feminist scholars like Patricia Hill-Collins, Kimberly Crenshaw, Jennifer Nash more recently, who have written about, theorized, and reflected on what intersectionality is as a concept and its continuing evolution and dynamic. What inspires me is much of Jennifer Nash's work, and she's written a phenomenal book on this a few years ago, which will come back to me, or someone can Google it and put it in the chat because my brain's gone blank. But she invites us to reflect on the ways that intersectionality travels. And I think this conversation is an example of that travel. It has traveled not only in discipline, in looking at international criminal law, but also in institutions and focusing our attention on the ICC or other tribunals. But as I understand of listening to the current prosecutor in mentioning intersectionality in his speech today at the Assembly of State Parties. So my goodness, intersectionality has traveled. So what do we understand of it? How should we develop it within our work? And I think that's where I'm interested in inviting us to reflect on it as a concept and a definition that could be expanded or is dynamic depending on who is interpreting it, who is understanding it, and the process in which they're applying it to. A judge at the International Criminal Court may understand intersectionality very different from an investigator, may understand it very differently if you go to a different tribunal, whether you're in the field or you're in The Hague, right? So our understanding of intersectionality is alive through the work of international criminal law, as well as the lived experiences of those who are the subjects to it, subjects of it. So I think it's one of the things I want to offer us. As a methodology, we may come to a position where we realize that just as with the concept of justice itself, intersectionality has some dexterity to it. And I'm interested in the ways that it is metabolized dependent on who is doing the work, the intersectional work of justice. I think it's clear that in this webinar, there is an appetite, an impetus, a commitment to do justice differently, intersectionally, which means that we also have to reflect on where the feminist movement in international criminal law has had its limitations till now, right? Why is the call for intersectionality happening now more strongly, more loudly? And I think we have to be candid with ourselves in reflecting in the ways that intersectionality reminds us that race, class, gender, these different types of intersecting oppressions have not been dealt well when it comes to international criminal law. So one may be a victim in Uganda, one may be an African woman with multiple identities. We heard Patricia talk about Yazidi women, but I think we have to confront ourselves with one of the foundational aspects of intersectionality, which is a conversation around race and class. And I think international criminal law, while wanting to embrace and understand and operationalize intersectionality in its work, it demands us to really think about how race, class, gender, physical ability, religion, a whole host of intersecting systems of power have manifested themselves up until now. What is the story that has been told now, and where is the work for intersectionality? I think in mapping that trajectory, it invites me to share a reflection from Patricia Hill Collins's work that intersectionality comes really from activist circles. And there is a grassroots bloodline to intersectionality, as well as it moving into the space of the university, where it becomes this critical social theory through the likes of Crenshaw's work. So that nexus between the activism of intersectionality and our theoretical, conceptual leanings, I think cannot be divorced. The example just given about Myanmar, I think is another way of thinking about how practice informs the operation of institutions. So when we're thinking about intersectionality in ICL, it's multi-directional, right? So it isn't and shouldn't only be located in the personnel of those who are more privileged on the spectrum, right? So again, I'm just going to use judges and investigators or people who work in civil society and NGOs, right? As opposed to victims and survivors. But at the same time, I think there is much for us to think about some of the resistance to the International Criminal Law Project itself that comes from intersectionality. Because when you look at it and you look at anti-discrimination law, we are challenging the ways that law has set about a current logic. So in Crenshaw's work and in her seminal essay, she's looking at anti-discrimination law in the United States, and she's pointing to the failure of the legal system, right, to think about the intersecting ways that Black working women in the United States were being rendered invisible by a system that wanted to reduce them to a singularity. So intersectionality is not only a way for us to understand lived experiences, to amplify that, but it is also a methodology to understand international criminal law and what it does. So it is a reflective tool on the very project that we are a part of and working in different elements, right? So I think one cannot forget that. It has to be a methodology that is continually self-reflective as well as operational. The other thing I want to offer us in our thinking about intersectionality, and again, I focus on this concept because I think one cannot assume and presume a common understanding, is that if you look at a kind of Black feminist epistemology, you see that fundamentally intersectionality challenges the universal. It challenges this idea that there is a vocabulary and a logic of universality. So one can look at all victims of sexual violence as having specific needs, X, Y, and Z, right? It departs from the universal to demonstrate that law, legal processes, legal personnel may render invisible, erase, forget, dislodge important power dynamics that shape the experiences of those who, again, are subject to the law. So I call upon us to be reflective in our way of understanding intersectionality through that lens, that it challenges universalism. And that may be uncomfortable. And certainly in activist spaces that I've been a part of in Northern Ireland, or whether it's work that is applicable to my work in transitional justice, I think that is where the discomfort comes in. When one is hinged to the universal project, and so perhaps less willing to really think about the transformative ways that justice could operate through an intersectional lens. So I'd love us, and I think if we have time for questions and reflections, it's something we can be open about and thinking about those tensions. Because I think the process of including intersectionality in the work of the ICC, of international criminal justice, is not one that's going to be smooth running. Whether it's the troll that we had at the beginning, or tensions in understanding, or resistance to personnel who may not see its relevance, necessity, or even applicability. And I think that's where I want to perhaps leave us with some ways of thinking about justice moving forward and intersectionality in that guise. I'm always inspired by the work of Kamari Maxine Clark and her invitation for us to see justice as an elusive endpoint, right? And for a number of ways in which I'm kind of thinking through intersectionality, I'm brought back to, you know, African feminist scholars, right? Because once again, our understanding of the origins, the histories of intersectionality can often lead us to a hegemony of understanding that concept from the United States. And I think there is so much richness and conceptualization, embodiment of intersectional practice when we look across the quote unquote global South. Whether you take from Professor Amina Mama's work, where she talks about African women having aspirations that go beyond securing their survival, political, economic, social, intellectual, professional, and indeed personal desires for change. She says it may be true that most African women are trapped in a daily business of securing the survival of themselves, their families, and their communities, but this is merely symptomatic of a global grid of patriarchal power and all the social, political, and economic injustices, end quote. And so again, when we're talking about intersectionality and how that could be a methodology that informs our practice, I think that call to really be attentive to power, positionality, difference is important for us in helping to reorientate where international criminal law, international criminal justice can go. Lily, I'll leave it there.
Wow, incredible. Thank you so much, Gratitude, for bringing us from the operational, really zooming us out, shaking us all, turning us around, and like really calling us on to reflect as individuals, to reflect as collectives, to reflect as the feminist communities of ICL, and much more beyond that. So thank you so much. And there are a lot of notes I took from the discussion, and being very mindful of the time, I now turn over to Adejoké. And you worked as an investigator, among others, at the International Criminal Court. And Yassin was talking about intersectionality in and of itself in a multi-layered manner is actually there to address existing accountability gaps. So I was wondering whether you could give us a short insight into some of your thinkings around intersectional approaches to international criminal law and practice. And thank you so much for joining the discussion today.
Absolutely. Thank you so much, Lily. And thank you very much to the organizers. I really do appreciate having heard from fellow panelists. I agree, just as they have indicated, that intersectionality requires us to pay attention to the lived experiences of the survivors of atrocity crimes and not make assumptions as to the nature of the harm they've suffered or the type of remedy that they should get. Before I go into the type of work that I'm currently doing, which actually deals with sexual and gender-based crimes that fall at the intersection of different legal regimes, so whether you're looking at international humanitarian law, international criminal law, international human rights law, or national terrorism law, I just wanted to add to what has been shared already a few observations, so two key observations actually. So the way I see intersectionality is that it considers unique identities that are created from being a member simultaneously in different categories. So whether we're looking at race, gender, sexual orientation, social, economic status, to name a few, an intersectional analysis actually helps us to see that a unique identity has been created at this intersection, and therefore there is a unique harm. I think it's important for us to sort of visualize it that way, because then as practitioners who are, whether we're investigators, prosecutors, whatever, we're not just thinking about, okay, this individual may have suffered racial discrimination, gender discrimination, so on, but actually understanding that the harm that this person has faced is actually unique. The other point that I want to mention too is that we really do require a radical shift in the way we think about international criminal justice, and also training for all international criminal justice stakeholders if we are to truly address the problems and the harms of that one-dimensional approach to justice. As has been said already, an intersectional approach allows us to think about the different kinds of charges that we bring. But even before that, thinking about it from an investigation position, what kinds of investigations are conducted? What are the types of questions that investigators are asking? How is the evidence analyzed? And so on. So I think we have to think about it, across the board. We, of course, thinking about training, including the judges as well. But as we know, international criminal justice doesn't only operate in the walls of a court or a tribunal. So civil society organization, advocacy groups, donor agencies, and states also, I think, have to take a moment to consider ways that they have embraced a unisectional approach to international criminal justice that resulted in the full extent of the harm suffered not being properly acknowledged. And I do know that single focus narratives are sometimes easy to push, especially to policymakers, UN Security Council, for example. It was a single focus narrative on rape as a weapon of war that got us the Security Council Resolution 1820. However, if we focus only on that, we miss all the other ways in which different forms of sexual violence and people are actually experiencing different forms of sexual violence in conflict, for example. So I think, as has already been said, it's important to ensure that the narratives are survivor-centric and they focus on addressing the systems of oppression and the vulnerabilities exploited and targeted by the perpetrators to ensure that justice, however we define justice and however it's manifested, is truly done. And on this point, I want to refer to a comment that Margaret de Guzman made in her article titled "Choosing to Prosecute: Expressive Selection at the International Criminal Court." And she notes that one of the functions of international criminal law is to expressly condemn the breach of the values that it protects. And I believe that when we apply an intersectional lens to our work, this is precisely what we are doing. So focusing specifically on accountability gaps in the work that, in what I've seen, the work that I do, a key challenge that I've observed working with national prosecutors and investigators who are looking at crimes such as crimes committed by ISIS and Boko Haram is that sexual and gender-based crimes are hardly investigated, talk less of even prosecuted across different jurisdictions. I know that there are one or two cases here and there, but terrorism charges predominantly center on membership of a terrorist organization or terrorist financing. And the result of this is that the totality of the harm and the experiences of victims are not captured, even if those victims are relied upon as witnesses. So as I say this, I'm also aware that there's discussion around in various academic circles about whether national terrorism legislation should be used to prosecute conflict-related sexual violence or not. And I wouldn't delve into that debate. But by giving this example, what I'm trying to point out is that the experiences of those who have actually experienced those crimes as an act of terrorism, by not prosecuting those crimes, indeed as an act of terrorism, we are rendering those people invisible. And a good example of where intersectionality was adopted to address the issue of using sexual violence and gender-based violence as an act of terrorism, of course, the Special Court for Sierra Leone in the RUF trial, where it was recognized, where the link between sexual violence and terrorism was recognized. And this actually, not only was that in the judgment, but it was also in the sentencing judgment. And the judges considered that the way sexual violence was used actually made the occurrence of the underlying crime more grave. So an intersectionality lens allows us to fully comprehend the gravity of the offenses, which may not be captured when national prosecutors use the standard criminal codes, for example, to deal with rape. You're not going to be able to capture the gravity of the context in which the crime occurred. So I believe that, especially thinking about national prosecutions, prosecutions of sexual and gender-based violence occurring in armed conflict, an intersectional approach will require using the laws that are available. adopting cumulative charging, for instance, to ensure that the extent and gravity of the harm suffered is captured. And I'm actually quite pleased to say that it's due to this intersectional approach that we actually have the first set of charges of sexual violence, including forced marriage and rape, as an act of terrorism in Nigeria, using the Nigerian Terrorism Prevention Act. And I'm happy to discuss that more if we have time for questions. So I'll stop here now, but I also want to recognize some practical challenges that have been raised by the different national investigators and prosecutors I've spoken with. And I think it's important to think about these practical challenges, because if we don't, we risk intersectionality being a buzzword in international criminal justice, but then there are no actual legs for it to stand on. So 2 practical challenges that have come up. 1, resources. This is repeatedly stated whether I'm speaking to a prosecutor in the Netherlands, Germany, or in Nigeria. At the end of the day, they feel like they don't have the resources to be able to engage in the types of investigation prosecutions that a proper intersectional approach will require. The second is also just in terms of policy and strategy. When you're dealing with terrorist organizations and terrorists, in a way, if the policy is to get the terrorists off out of the streets, then you will go for the easiest thing to prove. So that's why we see membership, we see support for a terrorism organization being really easy. And so the idea then for those who adopt that prosecutorial strategy is, hey, we can get them off the street, they'll be thrown in jail for a long period of time and they're off. But of course, the experiences and the full gravity of the crimes that they've committed is, is rendered invisible. So I think it's really important for us as we discuss, intersectional approach, we have to also discuss how do we address the practical challenges, because in speaking with the national prosecutors and investigators, it's not that they don't want to investigate sexual violence, and it's not that they don't want to look at the proper context in which sexual violence occurred. The idea from their perspective is that they're faced with different challenges, from a policy that comes from above to lack of resources. And so I believe that the conversation needs to include ways that we can tackle this from a concrete and practical level. So I will leave it there. And I thank you so much for inviting me to join this discussion.
Wow, amazing. Thank you. And this was really a stark reminder again that these approaches, they cannot be theoretical. They cannot just happen in virtual spaces or even in personal spaces, but we have to build bridges, and we have to build bridges collectively to some of the working realities, both of investigators and prosecutors, and to the very persons that kind of uphold the design of the system that is international criminal justice, and see where strategic intersectional interventions can be made. I'm very aware of the time, but I also want to say that I don't want to hit it off in 5 minutes. When the clock hits, I do understand people need to leave, but I want to conclude this discussion with those who want to stay with us. Our last speaker is Anna Martin, who together with me and others in continuous conversation really conceptualized this webinar series, which is kicking off today. She's writing her doctoral thesis. I think we are in the moment of completion almost on the operationalization of intersectionality in ICL, particularly around prosecuting sexual and gender-based crimes. So without further ado, I give the floor to you, Anna.
Hi, Lily, and thank you very much to everyone for being here today. I'm very conscious of the very short time I have, so maybe just to throw out 3 ideas that I consider important. One is that I see that there is actually a framework between feminism and human rights, understanding intersectionality that applies to ICL. I see intersectionality according to feminism and human rights as a tool to contextualize violence from the perspectives of identity and discrimination, discrimination against identity. And this tool helps to understand the root causes of violence as compounded discrimination. This perspective is necessary to understand how the harms are specific and aggravated. And this is necessary for an effective remedy, a remedy that is non-discriminatory and that is effective because links the harms to the root causes. The CEDAW committee, it has been mentioned in General Recommendation 28, frames intersectionality in those ways, understanding gender interlinked with other identities and factors to understand the gravity of the harms and their specific nature. So I see this framework of intersectionality helping to understand causes, harms in view of an effective remedy applicable to international criminal law. And then I would like to suggest some ideas why this is applicable. And the main reason why I see this is because we are talking about categories like discrimination, identity, gender, and these are not new to international criminal law. One of the main reasons that has been argued why intersectionality is not applied, or so what's the problem? Is it contrary to the principle of legality? This has been one of the main reasons argued why intersectionality may be difficult to apply in ICL. And I would like to just briefly comment why this is not the case. Intersectionality is a tool to contextualize violence from the perspectives of discrimination against identities, complex discrimination. These are not foreign standards to international criminal law that are transposed directly from feminism or human rights. Intersectionality calls for an understanding of the dynamics of violence at a stage prior, before the interpretation of the law. It calls for an understanding of the violence so that the law can be better interpreted and applied. Therefore, it leaves the conducts and modes of liability untouched. Intersectionality also has to do with many values, I would like to remark, that have become today's customary law. We are talking about the prohibition of discrimination prohibited by every human rights treaty, and we are talking as well of issues like the prohibition of gender-based violence as a crime of discrimination. Intersectionality helps to understand the dynamics of violence from these perspectives, therefore helping to interpret the law while respecting those values. And the last commentary I would like to make is intersectionality has a great potential to operationalize Article 21.3 of the Rome Statute, because it understands the violence from the perspectives of non-discrimination against identities, and therefore it uses categories that come from human rights like discrimination, identity, gender, therefore helping to apply the law, international criminal law, in consistency with these human rights categories. And by identifying those categories that are most hardly stricken, that are targeted, intersectionality helps to understand what harms should not be excluded from the legal examination, because this would have discriminatory effects for victims. I would leave it there. I would like to mention many more things, in particular some specific contributions that intersectionality can make to ICL, like helping to understand the criminal intent, the gravity of the harms, the rationale interpreting the law, and also helping to establish the inherent nature of sexual and gender-based violence, my field of study, to the attack, to help and bring linkage evidence. But I would leave it there, and I thank you very much for the great panelists that we have had. Thank you.
Thank you so much, Anna. And for the last few minutes of the webinar, I invite all panelists and discussants, and also those who provided opening remarks, and as far as you wish to rejoin the discussion. And I would like to just take some of the aspects that were mentioned in the course of the conversation to bring back for broader discussion. So I think one overarching issue with respect to intersectionality really is time. Patricia was mentioning intersectionality cannot be ahistorical, and intersectional approaches may also require fundamental structural change in the way work is being carried out. And we also may need to resort truly to reflective practices such as really envisioning and our imagination when looking forward. And an overarching question that I kind of pulled out of Yassin's intervention was, why intersectionality now? And there is a global reckoning that has occurred around many world events in recent years, but they do connect to broader solidarity struggles of persons fighting on a daily basis for their liberation and equity. So I was hoping to get some of the panelists' reflections on why intersectionality now, and what do you think is intersectionality's relationship to time in the space of ICL? And please feel free to jump in as you wish. For those who are still with us, for the audience, please also feel free to post your questions either in the chat or the Q&A for us to see. There are a lot of questions around whether the recording will be available. Yes, it will indeed be available on the YouTube channel of the Transitional Justice Institute, as well as elsewhere, and everyone will be informed. And I hope now to return to the question around intersectionality and time to some of the participants. And I connected to one of the questions in the audience that is from the Institute for African Women in Law. And the question is, how can we ensure that the people who work in the spaces in ICL understand intersectionality and treat all women, races, genders with dignity, equality, and respect? Yeah. Is there anyone who would like to offer a first reflection?
I'm just going to jump in, but I really asked my co-panelists to come abroad. I think for the last question, in terms of how can you ensure that professionals treat women, races, gender with respect, it's institutional culture. You understand that if that is not your approach, then you are at the wrong institution. I don't think you even have to believe in intersectionality in order to be respectful and to treat others with dignity. In terms of the timing, why intersectionality now? Well, I think that we have to, in some ways, understand that the feminist perspective, and when I say feminist perspective, I'm speaking about feminist perspective that comes from Africa, that comes from the WEOG countries, that comes from Asia, has always been informing international criminal law during the past 25 years. There's been a lot of pushback, there's been a lot of going forward. Sometimes it comes in on a very discrete issue, such as beginning with rapes, and sometimes it can really have a much more broader impact, such as right now understanding not only what is gender analysis or what is contextualization. So I see intersectionality coming now as part of that outgrowth of this enrichingness that feminism has given international criminal law. But it has to be, as Yasmin said, it has to be a feminism that really loses its own hierarchies, that loses its own racist and geographical preferences, that loses its own privileges and prejudices in terms of who can speak, when can they speak, and when is it important. So I think intersectionality is part of that outgrowth. And maybe 10 years from now, we'll be talking about another theory that really is the complement and the evolution of intersectionality.
Another question from the audience, from Farzana Ali, who is still in law school and expresses their frustrations and maybe discouragement to pursue a job in international human rights work because of the very system that this work is based on. And their question is around, in what way can an intersection approach to international system challenge the colonialist ideology underpinning these systems? For example, by holding the global North accountable for its crimes, empowering advocates from the global South, and moving away from the view that global North are champions and savers of the rights of peoples of the global South. Anyone who wants to jump in, please do, or any reflections you had. I think Yassin, your interventions were connected to this, so please jump in.
Sure, I think so much of that is the way that intersectionality, and it's Patricia Hill Collins who talks about, you know, the kind of matrix of domination, right? So that goes back to how intersectionality sees the ways in which the crimes that we're talking about, genocide, rape, crimes against humanity are manifestations of this power structure at a global level, right? And fundamentally, it's what the feminist movement has also talked about in terms of unveiling the kind of bigger structural things, as well as the individual carceral responses. But I think intersectionality particularly recognizes the kind of colonial aspects of it, the racialized aspects of it, the afterlives of colonialism and racism across the globe and its different manifestations. Intersectionality will see the caste system and what that may cause in regards to violence that is related to that, religion and ethnic identity. So I think, again, it goes back to using it as a methodology to understand what is that global power structure, right? The matrix of domination and how that is represented, manifested, investigated when it comes to international criminal law. I think it's, you know, it's part of the lens, as it were, when we started talking about this very early on. And someone mentioned it in terms of being used as a lens. So I think that's how it helps us to see that as much as many of these crimes that are being focused on are located within the global South, excuse me, some of the critical causes of conflict, let's just take the arms trade as a very basic example, right? As something that is linked to industries very much in the global North. So I think use it as a methodological tool to unveil that. And again, push for where international justice and its universal aspirations should also focus its lens.
Thank you so much. So true. Arms trade, very emblematic of all these conversations that we had, and also all the upcoming attempts to hold corporate actors, predominantly those based in the so-called global North, to account and understand their influence in mass atrocity more accurately. Another question, and that's perhaps for Adejoké or Shyamala. Do you see any possibilities, based on the discussions that we had, to actually transform the structures of intersectional equality and discrimination also inherent to the system of ICL, and that cause sometimes the facilitation of victimization by introducing intersectionality in such spaces? And overall, what do you view as some of the aims of these efforts behind it? Some solutions were touched upon, but more specifically when it's around structural transformation of institutions as well.
I'll just jump in there with a few, I guess, a quick observation. I think, you know, we're seeing a shift. The fact that we're having these conversations, we are definitely seeing a shift. And a key way to address some of these institutional challenges, I would say, is ensuring that the people who are seated at the level of power or in the position to make decisions, in the position to drive prosecutorial strategies and so on, are reflective of those, if we're going to use the term, you know, that was coined earlier, mentioned earlier, the global South. So if the crimes are that international criminal justice and the ICC and so on are investigating and looking at, then we need to ensure that the people who are involved at the key stages of these mechanisms are actually those who can understand, you know, what it is we're talking about and what intersectional lens is hoping to achieve. And so I know that, I mean, I see that we are having the shifts and so on, and I'm a proponent of the fact that international criminal justice, its future is domestic in a way. So I think it's important to truly empower those in national systems to be able to advance international criminal justice rather than always looking to the institutions. A final point too, we get a chance to see a difference in like the judgments, for example, if the judges start to apply when they're trying to interpret the Rome Statute, for example, and using Article 21 and looking at, for example, at national laws of different systems, think beyond the laws that they typically go to, Eurocentric laws, and actually check to see if there are any laws, if there are any decisions from other countries that can help broaden their understanding of the principles, for example. So I think we should be brave to challenge these things, challenge the institutions, ensure that there is that the institutions are reflective in a way of the people that they are meant to serve. So those are just my preliminary thoughts on that.
If I can just jump in as well, I really do agree with what Adejoké is saying, and I have very little to add to that, except to stress again the importance of what I said earlier, which is diversity and representation is key if we want to really ensure that we are going to be even understanding and talking about an intersectional approach in the work we do. I think when we are situated in The Hague or in Geneva, and when the work we do is further plagued by COVID, and we realize that there are communities that are going to be excluded from being able to communicate with us because they either don't have the technology or they don't know how to use it, I think this should call for some introspection on our methodologies to make sure that we are also reachable and that what we do actually means something. And this then also I'd like to link to the fact that the ICC at the end of the day, the cornerstone is complementarity. We are supposed to be a court that is going to encourage national prosecutions of these crimes. Now we need to make it as national as possible from the very beginning. And I think that's really key, and everything Adejoké said, I think fits into that matrix.
Wonderful. Thank you so very much. Thank you to everyone who stayed with us 15 minutes after the time. And I think this is part of a new adaptive approach of seeing what new realities can be possible in the small and in the big. My infinite gratitude goes out to all the discussants today and all the discussants in the upcoming conversations. As mentioned in the original invitation, when we conceptualize these conversations, we hope for them to be a conversation starter, a space to ask questions, a space to maybe take some answers, but mainly questions home into our daily work together with colleagues, and start try and answer them together and then implement the answers as they are appropriate to the context in which we work in. Big changes start with small steps, and I hope that these conversations will inspire transformation in the mind and in the heart of many to come. I think we, as Ashley mentioned, we are walking on the tremendous work of some really incredible feminist lawyers, but we also have generations that are now coming and really want to do this work differently, and they see where some of the pain and hurt is being replicated in the systems as they exist. With that in mind, thank you so much to Patricia, to Yassin, to Shyamala, to Adejoké, to Ashley, to Lorraine, to Anna, to Rory and Sadie from the Transitional Justice Institute, and for everyone who stayed with us. Please spread the word about the webinar series. The recordings will be made available, and we will also, in the small team that we have, do the best to provide a meeting summary in writing for those who prefer to read. Stay updated in the Twitter account about the upcoming events and also about the information. We hope to make this part of a wider publication, consultation process that is public. So this is a collaborative effort that requires a village, as you can see. And again, gratitude for making the time, the space, and supporting these conversations. And I leave you there. Thank you so very much, and have a wonderful evening, everyone.